What the clarification on the ruling on the NMA? What exactly was the position of the court on that for the benefit of that? Was it dismissed? Was it rejected? Or what are we supposed to take out of it?
Well, the ruling is simply requires Nnamdi Kanu, the defendant, to enter his defense. It's not a pronunciation of guilt or not guilty. So that is why it's called a no-case submission. So the judge made a ruling that there's a prima facie evidence that needs to be explained. So in common parlance, it calls on him to come and mount his own defense. But there is the other aspect of the ruling that concerned extraordinary rendition. That very one is one that compounded us, because the extraordinary rendition of Nnamdi Kanu is so open and notorious. Two international institutions or two separate panels of the United Nations have made pronouncements regarding his extraordinary rendition and called for his unconditional release. Nigeria is a member of the United Nations and therefore bound to consider that and implement that decision. And in Nigeria here, 3 courts have made similar pronouncements. First was by the Federal High Court Omahia, which awarded him 500 million naira. And the Court of Appeal also pronounced that he was a victim of extraordinary rendition. And in the Supreme Court, the same Supreme Court that sent this case back to trial, reached the same conclusion, that he was a victim of extraordinary rendition. And all these things are of the record. They are all in the file. And we remember, when this trial was being conducted, these very documents were tendered in evidence. So it compounded us, it confused us, that the court now made a pronouncement that the extraordinary rendition had no evidence before the court, that no evidence of it was submitted before the court. And you remember, least but not the last, recently a Kenyan High Court made the same pronouncement. But well, if the court was misled by believing, by mistake, that these things were not in evidence, it also said and left the door open that such evidence be submitted. So we are coming back with that evidence, and it's going to be quantum and legion.
So what about the first application on the enemy?
Well, that one too, it wasn't in evidence that the Nigerian Medical Association has intervened. So it came as a surprise. Well, there's a short date given of 8 days for the NMA to submit its report. So somebody is ill, you know, I don't think NMA is going to change much of that. But I think the judge wanted to leave the record open to admit every possible evidence regarding this matter. But meantime, we are disappointed. Our client remains ill and remains detained. And we're not happy about that. His situation requires urgent and emergent care. So whatever the court says today does not mean that the government shall withdraw back. Just 2 days ago, I wrote a letter. A private hospital has also expressed readiness to admit him here in Abuja. For security reasons, I won't mention the name of the private hospital. But the government, if the government appears to have issues with taking him to the national hospital, we have given them an option of a private hospital also here in Abuja.
So it's safe to say that the application to be transferred to the national hospital was rejected?
Rejected? No, it's pending. Yes.
One other information.
It hasn't been rejected. It's pending. It's pending the admission of this report from the Nigerian Medical Association and the opinion of the Nigerian Medical Association. And you know, if you were in court, the judge had ordered that the committee or panel to be considered by the Nigerian Medical Association shall have a member from the national hospital. So national hospital is still in play.
Thank you very much.
One other information, please. One other information. We are saying that the judge has no jurisdiction whatsoever to try Nnamdi Kanu, because that particular issue of being a victim of extraordinary rendition must be determined, because and that one will be whether they will be the one that will confer jurisdiction on the court. And the court said there is no evidence before him. No, we are going to supply evidence before him that Nnamdi Kanu was extraordinary rendition. Then, having done that, there is no case to answer. So that you should go home with that. And if they fail to do otherwise, we will not see it as a war against the Igbos.
Yes.
And just like he said, two sets of rules. One rule for the Igbos and one rule for every other Nigerian. This is a unique opportunity for Nigeria to be circumspect and look towards a political solution to this matter, and especially as it concerns high crime and criminality in the Southeast. So we are all disappointed, but God has not spoken yet. We will come back and show that the extraordinary rendition was indeed included in the submissions made to the court, and then the judge, like the barrister said, will know whether he has jurisdiction or not. But for the Igbo people, this is your time to rise up and to speak up and to say enough is enough.
Mazen Nnamdi Kanu has case to answer, says by the judge. Ladies and gentlemen, welcome back once again to this channel. This is about Perspectives, your domain for unfiltered news and raw political analysis. Today, history did not just whisper. It spoke loudly from the Federal High Court in Abuja. The courtroom became a theater where law, politics, and identity converged. At the center was one man, Nnamdi Kanu, the leader of indigenous people of Biafra, whose name has become both a symbol of resistance and a subject of fierce legal prosecution. The ruling handed down today may look like a simple procedural step, but make no mistake, it is a ruling that shapes the destiny of a man, that tests the resilience of his movement and raises questions about the future of his people. The judge declared, "You have a case to answer," and with that, the court ordered Nnamdi Kanu to open his defense. Alongside this, the Nigerian Medical Association was directed to assess Nnamdi Kanu's health and determine if he's fit to stand trial. And I think this was given within a space of 8 days. But beyond the legal jargon, what does this ruling truly mean for Nnamdi Kanu, for IPOB, for Ndi Igbo, and of course for the fate of Biafra cause, and for the political journey of Ndi Igbo within Nigeria? That is what we are about to unpack. Not as a dry legal analysis, but a story of power, politics, and people. So my dear, stay with me till the very end, because today's ruling is bigger than a courtroom decision. It is a mirror of Nigeria's political soul. What transpired today in court? The morning opened with quiet tension. Lawyers shuffled papers. Security operatives, as usual, stood guard, and whispers filled the corridor. Everyone knew that today's hearing was not just about witnesses or lengthy testimony or whatever, but about a single crucial motion, the defense no case submission. This submission was Nnamdi Kanu's legal team's bold request, and the judge has just dismissed it now. Even if everything the prosecution has said were true, it does not amount to a crime under the law. On the other side, the federal government lawyers argued the opposite. I mean, that the prosecution had established enough evidence to require a defense. That serious allegation of terrorism and unlawful broadcast could not simply be swept aside. So, when Justice James Omotosho delivered his ruling, the court fell into silence. In clear terms, he said the prosecution had established a prima facie case, a case strong enough to require a response. And with that, the no case submission was struck out today. The ruling meant only one thing: Nnamdi Kanu must now open his defense. But the judge did not just stop there. In a move that surprised many people, he ordered the Nigerian Medical Association to conduct an independent medical examination on Nnamdi Kanu. Was he physically and mentally fit to stand trial? That was the question from the judge. Was the DSS, detention facility adequate enough for his medical care? The Nigeria Medical Association was given just 8 days to submit its findings. I mean, whatever they find pertaining to Nnamdi Kanu's health. Then in that moment, two stories were born. One legal, one human. Legally, the trial continues. Nnamdi Kanu can now, open his defense and, of course, face the judge. Humanly, the question of Nnamdi Kanu's health became, the central to the pace and fairness of the proceedings. Well, to me, this ruling wasn't surprising, and I have my reasons for that. First, prosecution's evidence on record. The government had already, presented witnesses and exhibits. Courts really threw out such cases at this stage unless the evidence is utterly empty. Secondly, appellate history. Higher courts had previously remitted part of the case back to the trial court, signaling that the trial should run its course rather than to be, prematurely terminated, just like that. Then thirdly, judicial caution in security cases. I mean, when charges involve terrorism and national security, Nigerian judges often, prefer to let the accused answer rather than dismiss outrightly. So, while IPOB supporters may have, hope for a dramatic dismissal, the practical realities of law made today's ruling predictable. Now, here are the legal implications. Kanu must now defend himself. His lawyers must prepare witnesses, documents, and expert testimony to counter the state's evidence. The Nigeria Medical Association report is very pivotal. If it finds him unfit, the trial could stall or probably shift dramatically. But if it finds him fit enough, the procedure continues. The process accelerates. But then, there's something we are not talking about. And I could remember vividly how far I raised about this concern. During my earlier analysis about this case, I had always maintained that the issue of jurisdiction should have come first before this application of no case submission. I mean, in all ramification, jurisdiction remains a sword. Even as the trial proceeds, questions linger. Does the Federal High Court have proper jurisdiction, given how Kanu was arrested and extradited? Should that have been decided before today? Legally, jurisdiction comes first. Because if a court lacks jurisdiction, everything else collapses. Whether you have evidence of where the person is actually taking life or what, every other evidence collapse. Yet judges often prefer to push ahead and let appellate court decide later. Well, that's what I'm saying in this case. What is the essence of this analysis? It is only the appeal court that will free Nnamdi Kanu, because jurisdiction cannot be swept under carpet before the law. It comes first before every other thing. Then, talking about the political implications. For Nnamdi Kanu himself, today's ruling locks him into the process. He cannot walk free. He must now fight within the courtroom. His physical health, will now be scrutinized in public view. For IPOB, the movement gains another rallying cry. Supporters will see this as a persecution. Opponents will see it as a proof of state authority. Either ways, IPOB's messaging machine will spin this into mobilization fuel. For Igbo and Biafra cause, the ruling neither ends nor erases the Biafra question. Instead, it deepens the sense of grievances for some and offers the Nigerian state another chance to show whether it can, deliver justice without bias. Politically, the Igbo nation watch closely, weighing whether this trial is a law in action or politics in disguise as law. Then, the fate of Biafra in light of today's decision. If Nnamdi Kanu is eventually convicted, IPOB may transform his image into that of a martyr, fueling radicalization. But if acquitted, Kanu returns with renewed moral authority. But in truth, the destiny of Biafra cause does not rest in one man or one courtroom. It rests in how Nigeria chooses to treat its own citizens. So, what is next? Kanu's defense must begin on the adjourned dates. The Nigerian Medical Association report will be filed within 8 days. The defense will now continue to raise jurisdiction challenges, likely preserving them for appeal. Politically, the trial will remain a lightning rod for both supporters and critics of IPOB. Conclusively, the gavel has fallen, but not on the Biafra quest, not on the hopes of millions, and not yet on the fate of Nnamdi Kanu. What fell today was a reminder that in Nigeria, law and politics are never far apart. The court has spoken. There is a case to answer. But beyond those words, the people will decide whether justice is truly being served or whether this trial is yet another stage in the theater of power. For Nnamdi Kanu, the days ahead will test his strength, his health, and his legal strategy. For IPOB and the Igbo nation, this is a defining chapter. Will it be a story of suppression, of resilience, or of reconciliation? Here on Abel Perspectives, we will continue to follow every development, breaking it down with clarity and context. If you found this video insightful, please don't forget to like, share, and of course, leave your comments as always. As always, your individual perspectives is very welcomed. And subscribe for more updates, because this is not just a legal case. It is a story of people, power, and the future of Nigeria. Until next time, thank you for watching.